I'm not going to speak about housing law, anything specific about housing law in particular. I'm just going to talk about the issue of evidence and how to assist you to help the judge to unravel the bag of wool that is your case. I don't mean that in any derogatory way, but very often they are like bags of wool. And we want to help the judge to find the facts in the case or to draw inferences from facts. And I've got some top tips, and I'm probably a bit quote heavy, so I'm going to make you do all the hard work. So what we're really looking at here is when the witness evidence can be relied on by the court, memory is unreliable, and credibility is not the same as honesty. Reliability of the evidence may be influenced by bias, wishful thinking. I have a lot of clients with a lot of wishful thinking, and people making mistakes, either mistaking what they remember or storing what they saw and then remembering it later. Oh yes. And lying. So basically, apparently your pants being on fire is not the way for the court to decide whether or not you're a liar. We'll look at that in more detail in a moment. Okay, so in an attempt to seem eminently practical, and I look like a practical sort of person, don't I? One of the things you can do with this interesting half an hour is look at my notes when you get home and think about how you can use it as part of your processes in your practice. Use it, review credibility, I say, initially and throughout the litigation process, and more importantly, afterwards when you've received the judgment. Do it use some of these tips for evaluating your case at the start. A very exciting process of disclosure and exchange of witness statements. This is what I want you to do, really. I want you to I'm trying to create a culture of credibility awareness. You heard it here first. Basically, it is underpinned by the law, but it's a bit of a Cinderella area, and I don't think people sit around thinking too often about the law on credibility. And hopefully, after today, you're going to be completely enthused by it, and you'll be looking up some of these cases that I'm going to show to you. So the great big statement, the great catch-all statement about credibility is in this case of Onassis and Vergotis. But let's have a look at this, though. This is quite a good bit from it. It says, witnesses tend very easily and unconsciously to conjure up a legal right that did not exist. It is a truism that with every day that passes, the memory becomes fainter and the imagination becomes more active. So, effectively, I want to introduce you to some credibility conundrums, things that judges or lawyers who are trying to work out their case or work out their strengths and weaknesses of their case are going to be focusing on. So this case of Painter and Hutchison, effectively, an interesting quote from it, because it kind of sets up a kind of I spy of potential areas for credibility detection, and it's a brief quote, so I quite like it. So what it does is it sets out 9 things that are indicators of unsatisfactory witness evidence. Only 9, you say? Well, but they're quite good. They're quite good ones. So 1, evasive and argumentative answers. I should just say that, incidentally, I often write these things down when my own clients are giving evidence, and I think that was evasive and argumentative. Cross. Tangential speeches avoiding the questions. Don't answer barristers' questions. Blaming legal advisors for problems with the documentation. When you say, but that wasn't in your witness statement, they say, yeah, well, I didn't write the witness statement. The man sitting behind you did. Disclosure and evidence shortcomings, similar things. Self-contradiction, we'll come back to that later. Internal inconsistency. A shifting case. You start with a case in the defence or the particulars of claim, and it's completely morphed into something else as a result of the way in which the evidence is being given. New evidence that comes out during a trial, that's always quite exciting. And of course, selective disclosure, where people haven't complied with that duty and surprising things come out. Okay, so there are 8 themes that I want to look at in terms of the assessment of credibility. First, the witness's demeanour. So very often people think that they can weigh up their witnesses and the credibility of their case just by saying, I think X will be a very good witness. Okay, the court will try to assess whether or not a witness is trying to tell the truth simply by observing the witness in court, even though the court knows that human memory is often unreliable. This may not just be whilst the witness is in the box. This is quite an interesting little reminder to everyone. Miley and Friends, 2017 case, the judge says, it's advantageous for me to be able to observe the claimant not only when giving evidence, but also when he was sitting in the well of the court watching proceedings. So Big Brother is watching you. Judges are aware, though, that people perform badly under stress. Individuals may be unreliable or even dishonest, and other witnesses may actually seem just very confident, but may not actually be being honest. So we all have those very confident witnesses, and that is not the same as honesty. So in the case of Miley, Mr. Justice Turner again said, judges should exercise some caution when seeking to determine the credibility of a witness, wholly or mainly on the basis of an assessment of his or her demeanour. Generally speaking, other methods of appraisal, where available, may well tend to be more reliable. So effectively giving a warning that a multi-method approach, so 1, 2, 3, 4, 5, 6, 7, 8 of the 8 things we're looking at, the more you look at them from that sort of perspective, the better the evidence is in terms of credibility. So the second point of the 8 is how inherently probable is the witness's evidence. So in Onassis, Lord Pearce looked at the need to look at probabilities as well as the documents and admitted or incontrovertible facts when weighing the credibility of a witness's evidence. And we'll come back to contemporaneous documents and incontrovertible facts later on. So third point, is the evidence consistent with the admitted or indisputable facts? So what are an example of admitted or indisputable facts? I seem to have spent far too much time dealing with noisy neighbours and such problems that those cause. In a noise case, an indisputed fact is the fact that there were, and everyone agrees, 7 people living in a 3-bedroomed house, and or that whether or not the evidence is consistent with admitted or undisputed facts such as those is something that the court can look at. So again, in Onassis, it's referred to the importance of considering any admitted or incontrovertible facts. Lord Bingham, in a book in an article called The Judge as Juror, said, the first step in resolving it is to add to what is common ground between the parties, which the pleadings in the action should have identified, but often do not, such facts as are shown to be incontrovertible even though the parties do not agree. Number 4, is the evidence of the witness corroborated or contradicted by contemporaneous evidence? The best known statement of principle is that of, again, Robert Goff in The Ocean Frost. I have found it essential when considering the credibility of witnesses always to test their veracity by reference to the objective facts proved independently of their testimony, in particular by reference to the documents in the case. The next point here is on a case which is called Guestmin. This is a very important case on the issue of honesty. And in that case, Mr. Justice Leggett said, the best approach for a judge to adopt was to place little, if any, reliance at all on witnesses' recollections of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary evidence. This does not mean that oral testimony serves no useful purpose, but its value lies largely, as I see it, in the opportunity which cross-examine affords to subject the documentary record to critical scrutiny and to gauge the personality, motivations and working practices of a witness, rather than in testimony of what the witness recalls of particular conversations and events. However, there are a few caveats to Guestmin. In NatWest Markets and Bilter, this is quite obvious, but it deals with where there are no documents. In some cases, it will not be possible to take the approach adopted in Guestmin, where there are no relevant contemporaneous documents, or where those documents that are available are ambivalent or otherwise unhelpful. There the judge may have little or no choice but to assess the overall plausibility of the oral evidence and the credibility of the witnesses. Point 5 of 8, so I'm going to speed up. Are some contemporaneous documents more reliable than others? In the case of Sinclair and East Lancashire Hospital, the Court of Appeal dismissed an appeal against the trial judge's findings that observations in contemporaneous clinical note of a ward round were inaccurate. The court set out some principles about contemporaneous documents. It says, whilst it is too obvious to need stating, that means the Court of Appeal getting a bit grumpy, the fact that a document appears to be contemporary does not absolve the court from deciding if it is a reliable record and what weight it should be given. Some documents, such as medical records, are by their nature likely to be reliable, and others may be less reliable. For example, if written by someone with a skewed or imperfect understanding of the issues or with a bias of some sort. What about when the documents that you're expecting to be in the case aren't there? Is it all over? Point 6. So inferences to be drawn from the absence of supporting documentation. So in the case of Mumtaz, it was found that the absence of contemporaneous written document could be significant when assessing the credibility of a witness, where, for example, the judge is satisfied that certain contemporaneous documentation is likely to have existed and that the party adducing oral evidence is responsible for its non-production. But in the case of Terry and Watchstone, where there was an absence of a written agreement which was material to the case, although the absence of it counted strongly against the conclusion that there was an agreement, and the fact that the agreement didn't exist, wasn't there, several factors outweighed the lack of documentary evidence in that case. So in other words, the case was put together rather cleverly in a particular way. The court could find that all the directors were in agreement that there was an agreement. They were unanimous as to the essential ingredients of the agreement. An investigation after the sale of the company had concluded that there was an agreement, and this had led to the signing of a memorandum to that effect. So if you've got a missing document, perhaps, that you think is useful, and it's gone, it might actually not all be over. 7 of 8. So Lord Bingham considered the main test to determine whether or not a witness is lying also include the internal consistency of the witness's evidence and the consistency with what the witness has said on other occasions. In the case of Baker and British Gas Service, the judge noted on paper the evidence of the defendant's key witnesses looked strong, but after assessing them in the witness box and noting the inconsistencies between what was said in their statements and their oral evidence, she said she was less impressed. Nonetheless, nonetheless, the courts do recognise that where there is an inconsistency in a witness statement, that does not mean that the witness is necessarily dishonest in everything. If the court concludes that a witness's evidence is reliable on one point, the judge is entitled to conclude that the witness's evidence is not reliable on other points, and vice versa. What about where the witness is known to be dishonest? In Slocum, it was submitted that the evidence of one of the claimant's key witnesses should be rejected because he was fundamentally dishonest and had acted for his own financial gain. However, the judge in that case considered the fact that an individual had acted dishonestly did not mean that they therefore were dishonest in everything they said or did. The judge stated that having looked at the witness under intensive cross-examination and having assessed his answers against many contemporaneous documents, he did not find that he was lacking in all credibility. Interestingly, the judge noted that the witness had agreed to give evidence and subjected himself to a very uncomfortable cross-examination, even though he was not a party, he wasn't compellable, and he'd come all the way from Switzerland. I'm not sure that it's Switzerland that's the important point. Don't take much from that. Accordingly, the court did not reject the witness's evidence, but stated it had been treated with great care, which is a nice gloss on everything, that meant examining it against the contemporaneous documents and other evidence on all the relevant issues. It also meant considering the inherent plausibility and consistency of the evidence. On some matters, the evidence was found to be less than frank, but on others, the witness was found to be telling the truth. So, 8 points, and probably what I would do is if I was inspired as I feel you are, then I would probably create some kind of credibility assessment template, and certainly use some of those headings in terms of preparing some assessment or file review. Okay, but I would say that, wouldn't I?